Good afternoon. Welcome to September's Planning Lunches at Noon webinar, Changes to Planning and Zoning Laws in 2024. I'm Noah Hodgetts, a Principal Planner in the Office of Planning and Development at the New Hampshire Department of Business and Economic Affairs. I'm joined today by Natch, an attorney at the New Hampshire Municipal Association.
Good afternoon, everyone.
Here's a quick reminder on how to use the Microsoft Teams webinar controls. Please put your questions in the chat and we'll do the best to answer them during the webinar. A little bit different from past OPD plan webinars, due to the technical nature of a lot of the different kind of statute changes we're going to discuss today. Natch and I are going to do our best to try to answer questions as we go along. So please put your questions in the chat as we're going through the webinar. We may also have some time for additional questions at the end. And before Natch and I start going through the details of the statute changes, which are the subject of today's webinar, I'm going to turn it over to my colleague in BEA's new Division of Planning and Community Development, Leanne Moynihan, to provide a brief update about the Housing Champion Designation and Grant Program.
Okay, hi. Can everybody hear me all right? Can you hear me, Noah?
Yeah, we are good.
Okay. All right, good. Thanks. Hey, I just want to say thank you to Noah for giving me a few minutes here just to introduce myself and the program to you. This is such a great audience, so it's a great opportunity to talk to you just for a minute. For those of you who don't know me, I'm Leanne Moynihan, and I work at BEA under Invest NH, and I am heading up the Housing Champion program, which is a new program that'll be launching in the next few weeks. And this is an initiative to get municipalities to look at their housing needs and their housing ordinances. And it just very briefly, it is a grant program, but it's a little unique in that you need to establish yourself as a housing champion designated community first. And that's the first step. And that's what we're going to be rolling out again in a few weeks. There's going to be a few parts to it. It encourages zoning, which is flexible and open to housing, getting training for your land use boards, and encouraging infrastructure, both water, sewer, and transportation. And once you have that housing designation, then you will open you up to other grant opportunities, which will be coming along, which includes an MPU type grant, which gives funds. These are all funds directly to municipality. This does not go to developers. This is a program which just totally is focused on municipalities. So again, I didn't want to take up a lot of time. The grant program is a $5 million grant program, and it will be money for a per unit. For every affordable unit, there's going to be a $10,000 grant for municipalities that are designated housing champions, as well as funds for infrastructure, both water, sewer, and transportation, if it's focused on encouraging and increasing housing in your community. So my name is on the website right now, along with my email and phone, and don't hesitate to call me, but watch for more information to come on our website, and we'll be sending out a mailing and be reaching out to the community. So we want everyone to become a housing champion. This is not a competitive designation. Everyone can become a housing champion. Grants will be competitive, so the sooner you become a champion, the quicker you can move forward into those grant programs. Again, and any questions, please, this format is for zoning legislation, so save your questions for emails to me or phone to me, and we'll allow Noah to continue on with all his important information today. So thank you for giving me the time to talk to you, and I look forward to talking and meeting with all the members of the communities in New Hampshire. Thanks, Noah.
Thank you so much, Leanne. Much appreciated. So here are the 8 new laws enacted, or bills, which are now laws enacted in 2024, affecting the planning and zoning statutes, which we're going to cover today. Everyone who registered for today's webinar should have received both a copy of the slides along with a more detailed guidance document authored by the Office of Planning and Development and the New Hampshire Municipal Association, outlining in additional detail some of which beyond which we can cover in today's webinar, how communities should think about implementing these 8 new laws, which we're going to discuss today. And without further ado, I'm going to turn it over to Natch to talk about the first 4.
Thank you, Noah. Just one more thing about Housing Champions. We're very excited to see this program kick off. And in fact, we've already been in talks with some legislators about providing additional funding for that program. So I think it's very, very likely at this point in time that you're going to see a bill that would put some more funding to that program in the next biennium, because it is a budget year this year. With that, let's turn to things that have already happened. So the first bill we want to talk about was SB 437, which changes how local amendments to the state building code occur. Those of you familiar with the existing process will know that municipalities can adopt regulations, codes, local amendments to the state building code at the local level, as long as they're not less stringent than the requirements of the state building and fire codes. Now, there's been an open question, I would say, about what is less stringent. Does that mean a new code, or does that mean something that would be less protective of life safety? Those type of questions, and how do they evaluate that? Under existing law, when you do adopt those new codes, you do have to send them to the State Building Code Review Board for review and confirmation. This year, there was an update to the definitions in the State Building Code. We've now advanced to the 2021 codes, except for the Energy Code, that's still at 2018. And this ties into that because it also changes the process slightly, in that municipalities can only adopt amendments that relate to one article or section of the code. So, if you're dealing with, and I'll use an example from my friends down in Nashua, if you're dealing with sprinklered buildings and, you have a big mall or something, and you recognize that there are a lot of people there and sprinklers make a lot of sense, it may be the case that you want to change the section for, the size of that building for whether or not you can have sprinklers. Obviously, sprinklers are controversial. There is state law about that. So, review that carefully. But that's a new process. And if you have any existing locally adopted amendments, you do have to submit them to the Building Code Review Board. Now, I do want to mention one thing, because this came up in another context that you are probably not familiar with if you just practice in land use law, but it came up in a tax law context, and that was when there are updates to any sort of definitions under state law. It is, in fact, the case that you have to readopt your local definitions anyway, so you would still be submitting any local changes you wanted to make. You'd have to readopt and resubmit those to the Building Code Review Board. We've provided the email address for the Building Code Review Board so that you can contact them. And it looks like we have a few questions coming in here, so let me get that and address those. Can a town adopt the 2021 IEEC in its entirety, the International Energy Code in its entirety? No. You have to, what you can do at this point in time is you can address one article or section of the code. Now, is it the case there may be a number of sections that you want to change in the existing 2018 Energy Code that may result in those local amendments combined, mirroring the 2021 codes? That's a possibility, but you can't just say, hey, we're moving to the 2021 IEEC. You would have to take each component part and update that. Now, I do want to give you just a 2-second overview of the state building code, because many of you are probably in the same position that I was in that you are somewhat new to this. The state building code was enacted now really almost a decade and a half ago, a couple decades ago, in response to the fact that each municipality had adopted their own building code. The idea was we're a small state, let's combine under one code. And since then, there have been further refinements. I expect that we'll see further legislation revolving around the building code and how that functions. And so that's what this tension has been. And this was kind of the result that resulted in SB 437 this year. How do we, another question, how do we discriminate our non-building code regulations from those that are somehow tied to the state building code? Can we send in all our regs and let them sort it out? So I think it is important to recognize there's a difference between what you do with zoning, which is like what particular uses you can have in this particular area, versus the building code and the fire code, where you have, once you've decided on a particular use, the codes themselves regulate how that use can occur. So, is it the case that you have residential use here? Okay, and then how is that residential use going to be constructed? That's under the codes. So it would be better if you did clarify that. I recognize that a number of municipalities have adopted zoning codes that bleed into building codes and vice versa. Obviously, there's nothing you can do about that at this point in time. But what you do need to do, because of the requirements of SB 437, is go through your locally adopted amendments, decide whether they apply to the building code or decide whether they apply only to something like zoning, and then you're only sending in, you would only have to readopt and send in the ones under the building code. I don't know if you have anything to add to that, Noah.
Yeah, I think that makes sense. I think I agree with everything that Natch has said. I do agree that there can be, some communities have decided to package, as Natch said, kind of all their land use regulations together, including their zoning and their building code and their building codes. While statute talks about adoption of building codes and zoning ordinances in the same section, it should be pretty clear what is a local amendment to the state building code. It would typically probably reference, the International Residential Code, the International
Property
Commercial
maintenance
Code,
code.
Property Maintenance Code,
Yeah.
the International Commercial Code, the International Plumbing Code, the International Electric Code. There was a question about the International Energy Conservation Code. So something, it's really going to be an amendment that's specific to one of those international code sets. If there is a gray area and you have trouble sorting out what's zoning and what's building, our Natch and my contact information is at the end of at this webinar, end of the slides for today. Happy to help you kind of figure that out. But generally speaking, it should be clear what is a building code amendment and what is a zoning amendment.
Absolutely. All right, I want to move on to driveways here. House Bill 1202. This is a somewhat complex law in how it's written. There are really two provisions here. One applies to DOT, one applies to local planning boards. The DOT section is straightforward. DOT is required to issue driveway permits within 60 days of receiving an application for residential use, if not classified as a major driveway. I think that's actually 65, but I made an error when I made this slide. The local planning board is required to act on driveway permits issued by DOT within, this is actually 65 days, I know because I double checked this morning, of notification that DOT has issued the permit. It was, as this bill went through the process, that wording was changed. And so the law that actually went into effect, that second provision, is unlikely to affect any kind of existing local processes. I'm not aware of any local planning boards that take subsequent actions once DOT issues a driveway permit. Most of you say a condition of approval is you get a driveway permit from DOT, and then once that condition, any other conditions are fulfilled, it's done, but there's no concurrent jurisdiction there. So can't speak to the intent there, but that's how it currently reads.
Nate, can I just add something on the
Yes.
60 versus 65 days? The 60 days is actually not an error. I just pull up the language. The 65, the reason there's a difference between the 60 days for the DOT permits and the 65 days for the planning board is the 65 days for the planning board was supposed to match the 65 days for planning boards to render decisions. As Nate alluded to, there was the final language as adopted did not necessarily match the intent. But so the first bullet is correct as 60 days. The second bullet should say 65 days.
Thank you for that correction, Noah. I knew I got them swapped there. House Bill 1221, landfills are developments of regional impact. So if you have an application for a landfill, come before your board. If you have site plan review regulations in place and they come for that, or subdivision regulation, you must declare that simply because it's a landfill, that's development of regional impact. And the result of that is there's actually some specific notice processes here for landfills only. You have to notify all municipalities that are located within the same watershed and located within 10 miles of the boundaries of the proposed landfill. So if the landfill's on a border between you and another municipality, and there's one that's just under 10 miles away, it's kind of that other municipality between you, you still have to notify that second municipality. So just be careful there. I don't believe it's the case that many of you are affected by landfills, but just know that there is a particular rule now regarding those. And House Bill 1359, this is what I've always been referring to as the abutter bill. If you've heard me talk before, it does a couple of different things. The first one is slightly more complex language, but what it does is overrule the One Stop versus Town of Seabrook decision in 2021. In that decision, the Supreme Court decided that based on the wording of the definition of abutter, that properties that were diagonal did not qualify as abutters. Doesn't make a whole lot of sense for anyone looking at a map, because obviously, you have the two corners of the properties touching. Logically, they're abutters. So what this first provision does is fixes that, but in a more technical wording than diagonal, and also includes some other properties that are within 50 feet. And the reason for that is because, again, you could have a situation where you have a sliver of property that isn't really affected by whatever this proposal is, but then you have a property, 10 feet beyond that's someone's house or something that's, logically they're affected. They're going to see whatever this new development is. The second part of the law changes it overrides the Weeks Restaurant Corporation versus City of Dover decision from 1979. One of the questions that came up in discussing the housing needs of the state are, at what point in time did we see a lot of the type of housing that housing advocates are talking about being built? And when we went back and looked at the data, the answer was, well, we saw a lot of small scale developments that really, if you have any sort of delay in, simply become uneconomical to build back in the 1970s, and they've slowly trailed off over time. And so when we looked at some of the ways that those projects could be delayed, one of the recognitions was that Thanks to the Weeks decision, there was this 4-part test where essentially anyone who didn't like a development occurring could go in and challenge that development in court. And that doesn't make a whole lot of sense, right? So to use me as an example, I live here in Concord. I live in West Concord, but our building is right next to what I hope will one day be a new Costco. If for some reason I hated that Costco under the Weeks decision, the fact that I showed up and complained at the local land use board about the fact they're building a Costco or might build a Costco would somehow give me the ability to start a lawsuit at Superior Court. Again, I live like 20 minutes away. I live on the other side of Concord. That just doesn't make sense that I should have that. So this redefinition clarifies that it's abutters, which again has now been expanded, the applicant, and the municipality itself who can make these appeals. And hopefully that will cut down on some of the complaints by people who are not actually affected by development. And that went into effect on September 1st.
Great. Natch, I do see a couple questions
Sure.
related to that. I think you answered the effective date question. There's a question about, do these apply to historic commissions the same as zoning boards?
I believe that's the case. I'd have to go back and trace it. It was all of the references to any person aggrieved have now been deleted and been replaced with new language that's very clear that it's just the abutter, the applicant, and the municipality.
Great. Thank you. And I'm gonna, before I start talking about the next bill, House Bill 1361, there was an earlier question when we were still talking about building codes about where does MS4 fit into the building code. MS4, for folks that don't know, is a municipal separate stormwater separate storm sewer system permit, which is part of a EPA kind of regulation of on water. So for the MS4 communities that are primarily in the seacoast and southeast kind of corner of the state that are subject to MS4, most of that has to do with revising your stormwater regulations within your subdivision regulations, site plan review regulations, and sometimes your zoning ordinance as well, depending on where your stormwater regulations are. I am not aware of a situation where back to the earlier bill, where SB 437 and the new requirements for adopting local amendments to the building code would be affected by MS4. We do have a hand up. We are not able to unmute folks. So I'd ask you to please put your question in the chat, and Natch and I will do our best to answer that. So, sorry, I'm just trying to pull up my notes here. Everybody, hold on one second. I am fortunately turned off. Okay, so forgive me, I'm going to read off my notes on the other screen since my notes are not populating on this screen. So the next bill we're going to talk about is House Bill 1361, which is a rewrite of the existing manufactured housing statute, RSA 674-32, to clarify some of the archaic and kind of just confusing language and way the statute was organized. So in addition, House Bill 1361 now requires, or went into effect as of July 19th, required that municipalities, regardless of whether they choose under the kind of earlier sections of 674-32 to permit construction of new manufactured housing parks, to allow reasonable and realistic opportunities for the expansion of existing manufactured housing parks that existed as of July 1st, 2024. And I think another question may have just come in.
Yes, on House Bill 1359, should non-abutters be allowed to speak in public comment at a hearing since they have no standing? So the standing applies to the legal process. It does not apply to any sort of public comment period. So, at any public comment, any member of the public can come in and talk for however long you let them talk for.
Great. And another question, what if these current parks were never permitted? I.e. they are kind of non-conforming uses. That is Nate, you want to
Sure. So,
opine on that one?
I don't know how to resolve that specific issue, but if it's a non-conforming use that just continues, then, basically, you're going to have to talk to your town council about how your town lawyer to figure out how to resolve that particular legal issue. But assuming there's nothing you can do about the fact that it exists, and I assume in most cases you wouldn't want to anyway, you would still be allowed to still be required to allow the reasonable and realistic opportunities for their expansion.
Okay, we have another question from Herb, going back quickly to the new regulation about who can appeal on House Bill 1359. What is the date on which the new regulation, the bill that went into effect? So as Natch said, that went into effect September 1st. And would this apply to any case, including a cell tower, in which all towns within the 20-mile radius had to be notified?
So again, this applies to the appeal process where it used to say any person aggrieved. That's what changed. I know under 21K, there are specific rules for cell towers. I don't have those memorized, I'm sorry to say. So I'm not 100% sure whether there's a different appeal process there, but it's for the any person aggrieved standard is now gone.
Great. Okay, I'm gonna keep going to the next one. So House Bill 1371 grants municipalities the ability to include a waste reduction section in their master plans, which outlines a municipality's solid waste reduction plan, including ways to reduce solid waste disposal, such as increasing reuse, recycling, composting, or hazardous and electronic waste management. As probably most of you know, under the master plan statute, RSA 674:2, master plans only are required to include a vision and land use section, and then the statute goes on to list 17, basically something like 17 other optional sections that a municipality may also adopt as part or add to their master plan. So House Bill 1371 simply just adds a waste reduction section to this list of the may or optional sections. And this House Bill 1371 goes into effect next week on September 24th. So the next bill, which is the most contains the most substantive changes to the planning and zoning statutes, is House Bill 1400, which combines provisions originally contained within several different bills that were filed last session, including expansion of RSA 79E, a local option for governing bodies to make zoning changes, as well as the local regulation of parking requirements. So we'll start first with the expansion of 79E. So RSA 79E, the Community Revitalization Tax Relief Incentive, was expanded to allow the local legislative body of a municipality to establish tax relief for the owners of a building or structure currently being used for office use in whole or in part, if such use is converted to residential use in whole or in part. There was, for those of you that are familiar with kind of the legislative process, previous versions of this bill, which was originally in the Omnibus bill, SB 538, if I have that number correct. There was also language that got added in House Bill 1400 as signed into law that added an amendment to the definition of qualifying structure under RSA 79E:2, which also suggests that conversion of any industrial or commercial, you could use 79E for conversion of any industrial or commercial use or space to residential. However, there's no language in the rest of House Bill 1400 modifying this new or clarifying this new section of 79E for -D, which basically clarifies how the commercial and industrial spaces, what commercial industrial spaces qualify, and how that tax relief should be administered for 79E. So as such, we are recommending that really until this statute can be fixed, that this expanded use of 79E is really specific just to conversion of office space to residential use, and not the more general conversion of all commercial spaces and all industrial spaces to residential use. So with that in mind, House Bill 1400 also says that once a legislative body has said we want to adopt use of 79E for the office to residential conversions, the governing body then is responsible for designating the boundaries of that office conversion zone where the tax relief is going to apply. And this is a little bit different for folks that might be familiar with traditional, kind of, as I say, the kind of traditional 79E, which is specific to use in downtowns or village centers or town centers or other areas where there's been a historic pattern of development. A governing body can designate an office conversion zone anywhere in the municipality, anywhere where they would like that tax relief to apply. And this section is a temporary expansion, at least for now, with this use of 79E tax relief for office to residential conversions expiring as of January 1st of 2035. But it is in effect today. I also want to note that the statute, the 79E as modified by House Bill 1400 states that a municipality may establish criteria for the public benefits, goals, and measures that will determine the eligibility of qualifying structures for tax relief. Really kind of what are the kind of the guardrails for when a property owner can seek tax relief for office to residential conversions. And finally, there is, I'm not going to read the whole definition, it's contained in the guidance document, but there is a definition of what office use is in the statute as well. And again, as I said, that took effect July 1st, that section of 1400, and will be repealed if the legislature does not act on January 1st, 2035.
Couple questions here while you go to the next slide. Our current abutters list vested, or do we need to review and notice the corner abutters to proceed? What I would say to that is, I think that depends on when you had those abutters notices go out. If they were on or before the day before September 1st, I think you are okay with that. If they went out September 1st or after, then I think that you need to notify those diagonal abutters as well. And another question on 1359, 30-day notice of appeals, I imagine would need to be modified. Is there any template being made available? I know we don't make templates.
Sure.
I don't know.
So I think that's a really great point. We will keep that in mind. So just for folks that may not be familiar, in addition to the guidance document that OPD and NHMA have authored, OPD also authors or updates our planning board handbook and zoning board handbook to reflect legislative changes every year. We do have some templates. I will certainly make a note. I can't make any promises of when we do go to update those handbooks later this year. They'll be published before the end of the calendar year, of seeing if we can put together some kind of basic 30-day notice of appeal template that reflects the changes in House Bill 1359. Great. So I think we're caught up on questions now. I'm going to move along. Not seeing any questions on 79E to the next section of 1400, which is a new provision in RSA 674.18, so 674.18-A, which provides a local option for local governments with zoning authority vested in their legislative body. So this is the non-charter towns. So towns where you currently vote on zoning amendments at town meeting, village districts with independent zoning authority, and counties in which are located unincorporated places will now have the option to vote to allow their governing bodies to adopt amendments to the local zoning ordinances and the local zoning map. Again, this is an option. This is not a requirement. As I think most folks on today's webinar know, under prior law, only cities and charter towns, thank you, who are chartered and have town councils and have decided as part of their charter to delegate that authority to the governing board, were able to do so. So going forward, local governments who want to kind of take advantage of this new option should place the question on the warrant of a special or annual meeting by the governing board, or it can also be submitted by petition pursuant to RSA 39:3, or otherwise by acting upon the question of adoption on delegating this authority in accordance with the normal procedure for passage of ordinances in your town. And once the local legislative body has voted to delegate that authority, if they do so, just like any other voted town meeting, just needs a simple majority, then the governing body after that, by a majority vote any time of the year, could, as long as following the same procedures for adopting zoning amendments pursuant to, holding one full public hearing pursuant to RSA 675.7, any other requirements for notice for new zoning amendments, the governing body would then have authority any time of year to adopt amendments to the local zoning ordinance and map in the same manner that cities and charter towns currently do. And this change went into effect July 1st, 2024.
So I don't want to belabor the point, Noah, but I have spent a considerable amount of time explaining to legislators what local option means. So just to be clear, no town is required to vote on this. If you decide or somebody petitions to bring this forward to town meeting, then you would. But again, either the select board would have to put in a warrant article, or somebody would have to petition that warrant article to bring it to town meeting. You vote on it at town meeting, yes or no. Obviously, if you vote no, then you just retain your standard local zoning. If you your standard processes, if you vote yes, then you would allow the select board to amend the zoning. As Noah has emphasized here, cities, charter towns, you don't have to worry about this, because in the adoption of your charter, the people who adopted it already made the decision about whether to grant that authority to the governing body or whether to keep it with the local voters.
Great. And I do see a question here about, is this in addition to the planning board power to make zoning changes? So let's just clarify something off the bat. Cities, charter towns and non-charter towns, no planning board in the state has authority on its own to unanimously enact zoning amendments and change the zoning ordinance without the approval right now of the local legislative body. And non-charter towns or the governing body in cities and charter towns if they've given the governing body that authority. What the planning board does have the power, which it will continue to have the power to do in this as a with
System.
House Bill 1400, is continue to make recommendations. It will continue to have those public hearings for the zoning amendments, make its recommendation on whether to either the legislative body or the governing body, whether it believes that that zoning amendment should be adopted or not. That process does not change as a result of House Bill 1400. Okay, not seeing any more questions on this one, so we'll move on for the time being. So now we get to probably the most complicated section of House Bill 1400, which is the local regulation of parking. So House Bill 1400 contains two separate provisions related to local regulation of parking requirements for residential uses. The first authorizes the local legislative body of a city, town, or county in which there are located unincorporated towns or unorganized places. I realize that language is a little bit unconventional because we only have unincorporated places in New Hampshire, not unorganized places or unincorporated towns, but that is the language as taken out of House Bill 1400 as enacted. So that's what we got. And basically, this first section says any of these communities, the local authority of any of these different bodies, has the power to regulate accessory parking for vehicles subject to certain limitations. Importantly, accessory parking for vehicles is not defined in House Bill 1400, but presumably means a use customarily incidental and subordinate to the principal use and located on the same lot with principal use. And this first section, the first provision related to parking, limits the regulation of parking for accessory parking for vehicles to no more than 1.5 residential parking spaces per unit for studio and one-bedroom units under 1,000 square feet that meet the requirements for workforce housing as defined in RSA 674:58, Roman numeral 4. And it also limits the regulation of parking to no more than 1.5 residential parking spaces for multifamily developments of 10 units or more.
So, Noah, before someone asks the question, I'm just going to make it very clear. Nothing is said about commercial or other types of uses. Literally what is on the page is what this section says. So I've had a few questions already about, well, what about our regulations for commercial spaces because they're building, a new market basket or whatever. This section does not say anything about that.
Right. This section also does not address shared parking, so mixed use, where a building has a commercial component and a residential component, and the parking is meant to be used for both residential and commercial, and the residential and commercial uses. We have a couple questions. And I think the first question refers to the local option for the expansion of the governing body to make zoning changes. Could the warrant article specify administrative non-substantive amendments only go to the Board of Selectmen for adoption? So I think Tara is talking about like housekeeping amendment kind of things versus.
I don't think so. I think it's an all or nothing. I
would agree. Another question, or I think this is a comment. I usually read the RSAs on the New Hampshire General Court website. I see they are only updated as of October 23rd, 2023. Where is the best place to read the updated RSAs you refer to in this presentation? Great question. So everybody should have received the guidance document PDF before this email. It's also will be, I think it is up on our website, and it will be up on NHMA's website next week, and we'll also be disseminating that this guidance as well. That guidance document has a link to the final chaptered version of each of these laws that we're talking about today. Okay, more questions. As I expected. Is accessory parking different from regular residential parking requirements?
a good question. I don't know. And I do want to say at this point that it may make sense for Noah to talk about the second separate parking provisions in 1400 before we address some more parking questions, because I think there are going to be a lot more questions.
Great. Yes. I think that makes sense. Thank you, Nate. So I'm going to keep going. We'll come back to some of these. So if that's not complicated enough, we're going to add another layer. So there's this totally unrelated provision about parking, also in House Bill 1400, which says that if a proposed residential use proposes to meet the on-site parking requirements prescribed by a local ordinance or regulation with an alternative parking solution due to economic considerations, the planning board shall be required to consider the alternative parking solution. The phrase alternative parking solution is defined in House Bill 1400, the statute, to mean a proposal by an applicant to meet the parking demand created by a proposed residential use as a substitute for meeting the on-site parking requirements. In other words, once the parking demand is determined, if the applicant proposes a solution to meeting that demand other than by meeting the locally adopted on-site parking requirements, then the planning board must consider that alternative parking solution. I don't think we have it in the guidance or on the slide, but those House Bill 1400 does detail a couple of different kind of examples of what that alternative parking could be, or alternative parking solution could be. It can be anything from basically saying this residential use does not it's not going to have a lot of vehicle users for whatever population that might be targeting, and so we simply just don't need as much parking as the on-site parking requirements require. It could be the alternative parking solution could be there's alternative transportation that is a substitute for some of the users of the residential use might rely on instead of vehicles. The alternative parking solution could be a contract that the property owner has with a owner of a property, and they're going to basically lease off-site parking requirements from another off-site from a property off-site to meet some of the parking demand if the site does not have enough room to meet the ordinance's on-site parking requirements. So there's, as you can see, as to the earlier question, I would review that list of kind of examples of different alternative parking solutions. The language is not limited to that. I don't believe is limited to that list. But it's kind of given a good. Not. It's not. Yeah. Okay. Thank you, Natch. So going forward, once a applicant has said that they want to basically they intend to submit a alternative parking solution, basically what will happen is the applicant is going to propose that solution to meeting the demand as a substitute for meeting the locally adopted on-site parking requirements. Then the planning board is going to consider that alternative. What's really important to note here is that this second provision is not limited to a specific type of residential use. This applies to multifamily, this applies to single family, this applies to any housing development. And it also does not require the applicant, more than the applicant, to meet the to do anything more than meet the anticipated demand for the what they think, come up with a solution to meet the parking demand for the proposed residential use that they are applying to the planning board for. So, yeah, for example, sorry, go ahead. If an applicant proposes a large, I'll just say a 30-unit housing development and can demonstrate that the anticipated demand is lower than the locally adopted regulation, then the planning board must use the anticipated demand as a starting point for how many parking spaces that development is going to need. Now that said, the planning board, the statute, House Bill 1400 says the planning board has to consider this alternative parking solution. However, planning board is not required to accept that alternative parking solution if it does not believe that either the anticipated demand that the applicant is put forward is really what the true demand is, or that alternative parking solution is going to be adequate to meet that demand. However, it's important. The board can only basically, the board must request third-party review in order to basically contest the alternative parking solution and approval of the alternative parking solution. So let's think about back to this 30 unit development. So and especially as related to our earlier how this kind of relates back to the first provision about parking in House Bill 1400. So we have a 30 unit development. The ordinance or the statute says 1.5 parking spaces for this per unit for this 30 unit development. But the applicant attests that there's only going to be a demand for 1.3 parking spaces per unit. So the start of the inquiry about how much parking would be that going to base the solution based on the applicant's assertion that there's only a need for 1.3 spaces per unit, not the locally adopted, like I said, regulation. That's 1.5 spaces, two spaces per unit, whatever, or the statutory provision of a maximum requirement of 1.5 spaces. So you go through that whole analysis. The board ultimately, the applicant demonstrates that parking demand is 1.3 spaces and provides their plan for meeting the 1.53 spaces per unit demand. The board, as I said earlier, then really has two options. It can either, if it doesn't have an issue with what the applicant has calculations for the demand and its solution, it can obviously has a right to go ahead and just adopt and approve of the alternative parking solution that the applicant has proposed. If not, as I said earlier, if it questions that demand or the solution for meeting that demand, it can then go and request third-party review under RSA 676:4-B. And as I said earlier, which I cannot reiterate enough, I know there's going to be questions here. There is, as I said, I encourage boards. Obviously, there's going to be situations where there's not a question about the demand. If the demand is in question, the planning board has every right to request third-party review. And if the third-party review comes back and says either the demand does not meet, the applicant's demand calculations cannot be verified, or there's a question about that, or the proposed solution does not meet the actual anticipated parking demand, the planning board then would have the authority to then not approve of the applicant's alternative parking solution. So all that said, and then Natch, I think you want to add something at the end here. While municipalities which regulate residential parking, and I know there was a question earlier about whether it's in your zoning ordinance, whether it's in your site plan regulations, whether it's in your subdivision regulations, you should still go ahead and update your local regulations to reflect these new statutory minimums. In the first section, the 1.5 spaces for studios and one bedrooms under 1,000 square feet that are defined as workforce housing, as well as 1.5 spaces for multifamily developments of 10 units or more. While currently we do recommend updating your recommendations to comply with that section of the statute, everybody should also be aware that applicants have the right under this other parking provision of House Bill 1400 to challenge those parking regulations and put forward, as we've discussed, their own alternative parking solution based on what they perceive is the anticipated parking demand.
So just a couple of things I wanted to add. The vast majority of your municipalities do in fact have a 2 parking minimum requirement. Some are more complex, some are just straight up 2 for residential. So unfortunately, you do have the the misfortune of looking to see whether it is possible to update your regulations at the local level this coming March for most of you. The other thing I wanted to note is, I think as a practical matter, what you will likely see is in large scale developments, you're probably more likely to see developers say, hey, we have an alternative solution, and then focus on the demand rather than in smaller developments, which might be more likely to default to this 1.5 rule. But obviously, this is new. We don't know yet. And with that, there are a couple questions that came in that I'm happy to address, Noah. Skipping down one, there was a question about the abutter statute again, whether a corner abutter includes one that's separated by a road or stream from the subject property. It does. That does qualify as an abutter under this. And then we have a lot of questions on parking here. So local regulation of accessory parking needs to be authorized by legislative body first before the restriction of 1.5 spaces comes into play. You do have to have that. You do have to have that regulation in place in that manner. I don't know if you want to expand upon that, Noah.
Sure.
Again, I mean, as I think Noah has pointed out quite well over the last 10 minutes or so, there are a lot of questions.
Yes. So let's take the first part, and Natch, feel free to contradict anything I say here. So the first, and this really goes back into the effective date. So the first section, and this is also, I guess, important to note, the first section on parking, let me just make sure I got this right, that we talked about, the 1.5 spaces provision, first of all, which I neglected to mention, that section does not take effect until January 1st, 2025. That is not in effect today. The second parking provision about alternative parking solutions took effect July 1st, 2024. So, but with that, let me say that, again, as I said, most communities are not going to have an opportunity to amend their zoning ordinance until March town meeting. For many communities, the parking requirements are in their site plan review requirements, and or could even be in subdivision regulations. And so obviously the planning board, we encourage planning boards now or soon after January 1st to go ahead and amend your site plan and subdivision regulations to comply with this new statute. That said, there is going to be this group of communities that have their parking regulations in their zoning, which in which there will be a window between January and town meeting for which their parking regulations may be stricter, i.e., to Natch's point, requiring 2 spaces per unit, where statute only allows 1.5 spaces per unit. In those cases, Natch, I don't know, feel free to contradict me, but like the next bill we're going to talk about, my interpretation would be that the 1.5 spaces language is going to govern.
Correct. That's my interpretation. And I saw down below someone had asked a question about kind of how this 1.5 and everything applies. Just to be clear, this is the minimum that you would require at the local level. It's not any sort of maximum. So if the applicant comes forward and says, hey, I want to build 3 spaces per unit, that is not affected by any of this. It only affects them if they say they want to build, you're saying you have to build a minimum of 1.5 per unit. And if they're going to challenge that, it has nothing to do with if they want to build more than that. Did that make sense? I hope that was English.
Yes, I think to Natch's point, the intent here with the alternative parking solutions is to require less park.
It's not to limit a applicant from saying they want to build more units than you require, more parking spaces than you require at the local level, if you have a regulation in place.
Right. So I guess another way to put this is that if a applicant is proposing more parking than the local regulation, than the local parking requirements and statute requires, the planning board would still have authority to make sure the applicant is meeting the parking requirements and not building more parking than they need.
Then there was a question about the ZBA's role versus the planning board's role here. I don't know if you want to go over that again, Noah.
Sure, and I may have left that out because this is confusing. It gets confusing. So there is language in the second parking provision related to 1400 that specifically says, and let me just quote, I have it up here so I don't get it wrong as I pull this up. I thought I had it up, but basically specifically says that the planning board has authority to approve an alternative parking solution that may be inconsistent with the parking requirements in the zoning ordinance. So in this very limited capacity, the planning board, in effect, has the authority to approve something that is not consistent with the zoning ordinance. That'll be something that typically that role, as I think this question is trying to point out, would be where a zoning board would issue a variance. But in this very specific instance, the planning board has authority to approve an alternative parking solution that may be inconsistent with the parking requirements in its ordinance.
So to add a wrinkle to it, how would we advise them to proceed if a alternative parking solution was proposed in conjunction with a project that wouldn't otherwise go before the planning board, such as a standalone single-family home? Would the process be in accordance with the standard procedure of 676-4, where the only application reviewed is the alternative parking solution, or would the other process, some other process apply?
So I think we're probably thinking about a by right use where you're just going to basically, you don't need a public hearing. We're not going to go, and so there isn't going to be a public hearing. It isn't going to go to the planning board. Yeah, I guess in those limited spaces, yeah, the application is the alternative parking solution acceptance, but you're not going to require, if you don't need a public hearing, the alternative parking solution is not going to now necessitate a public hearing. So I think we're talking, maybe Joseph can clarify if we're just talking about a by right scenario where the residential use is effectively by right. A little, yeah. Nate, I don't know if you want to
Yeah, that's my
take another shot at answering that one.
That's my assumption is what we're talking about. And for some of my friends commenting here about maximum minimum parking restrictions, we're not going to comment on that. You guys have each other's number. You can call each other and fight it out offline.
And Joanne is asking a question of what statute does Part 2 fall under? So, yep. So this Part 2 is a new section, 674:16-A, labeled on-site parking requirements.
So the other thing I do want to mention, Noah, is that this parking section, we have, I think, about a third of our guidance documents dedicated to this. We did our best to make the two sections coherent so that they work together. Obviously, what we're trying to do here is make sure that anything passed by the legislature that can be enacted is enacted. I mean, that's obviously why they do it. So that's what we attempted to do. We do recognize that there are questions that we simply do not have answers to. That's all I want to say about that.
Yes. There was an earlier question which I only partially addressed, which I want to go back about just more kind of best practice. Can parking requirements be in zoning? And as I've already versus in site plan and subdivision. As I said, there is obviously communities that have parking requirements in their zoning address. From a best practice perspective, and I know we discussed this in OPD's planning board handbooks, we advise communities to put partially for this very reason, to take their parking requirements out of their zoning ordinance and put them in their site plan and subdivision requirements, so that it is easier to update. So obviously you can't change what's already been done, but going forward, especially for coming into compliance with the first parking provision, we would recommend that if you're thinking about coming to compliance, not a requirement, but certainly best practice to move those parking requirements if they're currently in the zoning ordinance, to move them into the respective sections of your site plan review and subdivision regulations.
And when your town asks you why, you can just hand them our guidance document and say, it's very complicated. It's probably the case that at some point in time, someone's going to file a bill to answer some of these questions. So it'd be way easier just to have it in your easier to update provisions than in zoning.
Great. So and then there's another question, what is a 0.5 parking space? So this really goes more on the demand side. And if you think about it, if you have a, say, and I'm not going to get the numbers right here, but if you have a 10 unit development, and you do the math out and you say,
Nine.
all right,
Pick 9.
Okay, pick 9. Thank you. All right, Natch has an example ready to go with 1.5 spaces. So take it away.
Yeah, so you'd obviously multiply 1.5 by 9, and then you'd have to round up because you'd end up with a situation where you'd have something that's not a whole parking spot. Obviously, if you do 10, you end up with 15. So I don't know what 1.5 times 9 is, but you would round up to the next whole number because the demand would be slightly more, or the requirement would be slightly more than one whole space. So it's really just kind of a math problem.
Great. Any more? I'm going to go on to the last law that I want to talk about. Just as a reminder to folks, we did schedule this to go to 1:30, knowing that we had a lot to cover and there was going to be a lot of these very specific questions. But if folks do have additional parking questions, feel free to keep putting them in the chat. So the last bill enacted, which has now been enacted into law, is House Bill 1567, related to the zoning provisions related to the regulation of home-based childcare. House Bill 1567 does two things. It alters RSA 672:1, paragraph Roman numeral V-A, which is the zoning ordinance, the statute related to the purpose of zoning. Isn't really though enforced. House Bill 1567 also adds additional language to RSA 674:16, related to the regulation of home-based daycare, as I said. And this replaces the existing language, as I said, in the zoning ordinance purpose statute in 672:1, which previously said that a community should allow 6 full-time preschool age children and 3 part-time school age children at a home-based daycare. It replaces that with a requirement that such home-based care shall be allowed as an accessory use to any primary residential use by right or by conditional use permit. If all requirements for such programs are adopted and consistent with the rules of the Department of Health and Human Services and their rules for child care licensing, which is HE-C4002. So in short, in a nutshell, what this says is If the home-based childcare conforms with the DHHS's childcare licensing rules, then a municipality is only allowed to has to allow that home-based childcare either as of right or via conditional use permit, or subjected to a conditional use permit. House Bill 1567 also states, there's a new section, RSA 674:16, Roman numeral VI, also states family or group family childcare shall not be subject to local site plan review in any zone where primary residential use is permitted. So what this means in short is that, so if you're a municipality, if you want to continue, you do have the option if you want to continue regulating home-based childcare by a conditional use permit. However, we recommend that you really be careful, pay careful attention to make sure, as a lot of conditional use permit requirements currently do not reference the site plan review requirements or seek to mimic the intent of site plan review. So you can still subject them to a conditional use permit requirement if you want, home-based daycare to CUP process if you want. It cannot be, it needs to effectively be less rigorous than what putting that use through site plan review would be. I do also want to note, because I know there's been a lot of questions from childcare providers on this. House Bill 1567 only affects the zoning of home-based childcare. It does not affect the authority of local health inspectors, fire inspectors, and code enforcement officers to regulate and inspect family or group family childcares to ensure compliance with the other health and safety requirements in the DHHS childcare licensing rules, HEC 4002. And this change will be going into effect next Tuesday, September 24th. So sorry, that was a bit of a mouthful too. Natch, go ahead.
Just one additional note for those of you extraordinarily curious. If I remember correctly, basically the DHHS rules allow one more additional child compared to what was previously in the statute, which was specified the number of children for some reason instead of just saying whatever number is authorized by DHHS.
Great. So we do, with all of the, I'm sorry, there was another slide. My apologies. So as I think I've referenced a couple times now, you should have all received a PDF of the guidance document, which effectively seeks to explain the 8 bills, which are now law, affecting the planning and zoning statutes authored by my office, by OPD and HSOP, the New Hampshire Municipal Association. We'll also be disseminating that guidance document to municipal planners and planning boards and zoning boards next week. And it's also available on our website. Alvina, my colleague Alvina, just also put the link to that guidance document in the chat.
And just one more thing, because there were a couple people doing math here with me in the final moments. We did, as I mentioned before, that the guidance document goes into as much detail as we could about the parking requirements, and they do apply in specific situations, but not others, as Noah covered. It's very complex, so I don't expect you to remember all of that. And that's why we hope that the guidance document would be helpful.
Great. And so here's Natch and my contact information. If there are additional questions, feel free to reach out to us. We do have a few, as I said earlier, we did schedule this webinar to go until 1:30. So I think, Natch, we've answered or done our best to answer all the questions in the chat up till now. If folks don't feel like we answered your question or have other questions, please feel free to put your question in the chat now. I'll give that.
And of course, if you come up with questions in 5 minutes after we hang up, Noah and I are available. Do feel free to reach out. All of your municipalities are members of NHMA, so we are able to answer your legal questions. I will tell you our legal services department is out today because they're giving a training on budget and finance up in Littleton. But they will start answering your questions tomorrow, or those will get passed along to me, and I will do my best to answer them. That I want to thank you all for coming today.
Great. Yes, I'm not seeing additional questions. I'll give folks another minute. Please remember to fill out the webinar feedback survey. I think my colleague Alvina just put the link in the chat. We'll also, for anybody, don't feel like you need to click on that right now, we'll also send out an email after today's webinar to make everybody aware when the recording of the webinar is available, along with the link to the survey. I am not seeing any more questions, so I think, I don't want to cut anybody off prematurely, but I think we are going to call it a wrap on today's webinar. I want to thank everybody for attending. I want to thank my colleague Alvina Snegic for assisting. I want to thank Natch Grays for helping me present this very detailed, complicated information about all these statute changes. And as my other colleague Leanne said at the outset of the webinar, please be on the lookout in the coming weeks for additional information about the Housing Champions designation and grant program. Take care, everybody. Have a great afternoon.